Before I introduce our guest speaker for today, I'd like to invite Mr. Sameer Srivastava, co-founder at the Vertex Blockchain, to say a few words.
Hello, everyone. I, Sameer Srivastava, welcome you all to this session organized by the Vertex Chamber on amendment on applicability of recent amendment under Insolvency and Bankruptcy Code. Prior to initiate today's session, I would like to give a brief description about our firm, that is the Vertex Law Chamber. The Vertex Chamber is basically a Delhi-based law firm consisting of 3 partners: me, Sameer Srivastava, Mr. Dipanshu Gupta, and Mr. Indra. So without taking too much time, I would like to request our moderator, Ms. Pragya Rao, to initiate today's session. Thank you.
Thank you so much, sir, for providing a brief about your organization. Insolvency and Bankruptcy Code was enacted in May 2016 and was necessitated due to a huge pileup of non-performing loans of banks and delay in debt resolution. This code applies to companies, partnerships, and individuals, providing for a time-bound process to resolve insolvency. Under this code, debtor and creditor both can start recovery proceedings against each other. The code has been amended from time to time since its enactment to remove bottlenecks and to streamline the corporate insolvency resolution process under the code. In 2020, the Parliament passed the Insolvency and Bankruptcy Code Amendment Act 2020, which received President's assent on March 30, 2020. To have an in-depth knowledge of the same, we have Mr. Kamal Ahuja as our guest speaker for today. Mr. Kamal Ahuja is the founder and proprietor of Lawmax, advocate and solicitors. Having legal career in mind, Mr. Kamal Ahuja started as an associate member of the Institute of Company Secretaries of India and performed wonderfully as a partner in Grover Ahuja and Associates, practicing company secretaries firm in New Delhi. Afterwards, he joined the Bar Council of Delhi and engrossed himself as an advocate. Mr. Ahuja is highly regarded for his versatile corporate and commercial trial skills for handling complex trade and competitive issues. He regularly appears as an attorney before numerous statutory bodies such as the Registrar of Trademark, RBI Regional Director, FITB, Indian Tax Authorities, and other regulatory authorities. He has handled a variety of cases ranging from intellectual property rights, corporate and commercial laws. He possesses a great level of comfort while handling thorny issues. He carries an experience of over 10 years in business advisory and legal compliances. He possesses extensive management skills. He is bestowed with high degree of knowledge and expertise while handling complex issues and is renowned for limitless dedication when it comes to being a part of the team. So without wasting much time, I would request our guest speaker to enlighten us today's topic, and I request all the participants to keep their cameras and microphones off before we begin. And in case of any questions related to the topic, kindly drop them in the chat box. The platform is all yours, sir.
Thank you, Pragya, for introducing me and giving us such an elaborate introduction of mine. And really, it's something imagining, appreciating for me also that I have such a kind of a style introduction you have given of mine. And I really would like to thank you, the Vertex Law Chambers, for giving me this opportunity to address a young generation or a team of professionals as well as a team of audience on the IBC amendments. I really would like to thank Sameer for inviting me for this seminar and addressing all of you on the amendments which have been taking place in the Insolvency and Bankruptcy Code. And I think since the time is a major constraint or major thing which we have to keep in mind for this webinar, so without wasting any more time, I would like to start the topic. And I would like to introduce, as just Pragya told, that it has been notified in the 28th May 2016. And now, let us go a little bit back when and how this IBC is being conceived and what was the objective behind it before discussing the amendments. So I'll be taking a small time on this issue first, and then we'll take up the whole changes which has been taking place and what is the present situation of the IBC Act in India as of now. So this act was basically started with the appointment of Banking Law Reforms Committee, which was headed by Mr. T. Vishwanathan. And what was the objective of banking law reformation of this committee is because before this IBC, in India, if you're talking about the insolvency or bankruptcy reconstruction, in any context, courts are there. For the companies, the corporates, there is basically the Companies Act, which is the winding up of the company. Okay, the 1956 Act, and when this IBC even came, it was 2013 something. And in that, basically winding up and voluntary winding up is being provided and it's being taken care by that. And in case if there is a default by the competitor for the loan borrowed from the bank, there is a RDDB Act. It is the whole name is restructuring debt and the recovery of debt due to banks and financial institutions, and Surface Act was there, which the banks would have the money from the corporate. They actually do PRT, the debt recovery to move from that is the SICA, Sick Industrial Companies Act. Sick Industries, SICA is Sick Industrial Company. They are different companies will be SICA, their rehabilitation, as well as under SICA there is a provision of formation of BIFER, Board of BIFER, Board of Industrial and Construction. And for the corporates, one place in the 2013 Act NCLT is there, and for the SIC companies, there is another mechanism which is a BIFER. BIFER practically deals with only with the companies or industries, basically, more specifically, there are manufacturing entities are there in the company. Those being treated to BIFER. Rest of the entities, if it is a trading company, service industry, there is no such provision is provided in the SICA. And SABASI Acts and RDDP Acts are being separately enforced by or used by the banks as a machinery to recover their non-performing assets on the banks or account which is being declared as an NPA. This is a whole mechanism available before this IBC and before the formation of, we'll talk about the banking law reform committee. And for the individual, there are two acts which basically were there of 1909. One is the Presidential Town Insolvency Act. Other one is there's one more act which is having the Presidency Insolvency Act. So both act, the Presidency Town Insolvency Act, basically takes care of the insolvency proceedings before or against individual in three major cities of India, that is Mumbai, Chennai, and Kolkata. And for rest of the cities in India, if somebody has to, then they have to take action under the Presidency Insolvency Act. So there are two mechanisms available for the individual, and for the corporate there are different provision under the NCLT, and the forums are NCLT and the BIFER. And for the individuals, if the person resides in the town in Mumbai, in the metro towns, then they have to go to the high courts. And for the other cities, it is to be routed through the district courts. So this is the mechanism which was available. And if somebody has been agreed with the order of the BIFER, then they can go to the high court and then onwards to the Supreme Court in the question of law. The whole judiciary, different forums are there for the recovery of the debt. And that creates lots of confusion, lots of ongoing proceedings before the various forums. And practically, the lenders and the creditors are not getting their money on time, and that hampers the growth of the business in any country. So, with the objective of to speedy the recovery of money for the banks as well as for the operational creditors, but the major concern was for the banks, as they are basically the backbone of the industry as well as for the economy of any country. The government wants that if a bank lends a money to a company or to an individual, that money should be back to the in a productive resource, in a productive channel, in a very fast or a speedy manner. So that was basically was not happening in India because of the multifarious forums and various acts, various provisions are which are being there to take care of the insolvency and bankruptcy proceedings. Before the this banking law reforms committee was formed, and when this committee was formed, they come up with this concept of insolvency and bankruptcy code, and where they provided there should be a I'll get the questions later on, whatever questions. Please hold on your question and it's putting up in the chat box right now. Please hold on your questions. We'll take it up at a later stage. Okay, let me finish my topic and please hold on and note down your questions and we'll be addressing all the questions once I'll be finished with the topic. Thank you. So, Banking Law Reforms Committee comes up with a uniform code proposal whereby they have provided that a time-bound process to sort out the insolvency as well as the liquidation process for the corporates. Basically, it will understood if somebody is not able to pay the tax, the first thing and the foremost thing is to revive the entity. Because if the money has been invested in some entity and the same entity can be revived, then the haircut, the cut in the debts which the creditors or the lenders have to be taken, that can be reduced up to a level. Okay, but if has to be wound up, and then they have to recreate an industry, then this is not a viable option. The first step in insolvency and by IBC code is the insolvency proceeding or we say it's resolution process or corporate insolvency resolution process proceedings, which has been providing in both the ways, and then comes a liquidation proceeding. Liquidation is basically when we are selling off, or in individual we say bankruptcy proceedings. Okay, there we sell the assets of the individual or the individual as well as the company and realize the money and pay to all the stakeholders in the order of their preference, which is given as we call it in the IBC the waterfall mechanism. Okay, the first the money will be given to whom the who will be eligible to first for the resources of the company and how the whole money which is left is to be distributed among the various stakeholders. So this is what is there in the IBC. Okay, so when this act was formed, the timeline was given, which was very quick. If I'll go and we'll talk about this 180 days plus 90 days for the CRP proceeding. And the similar proceedings we will talk about is applicable individual to individuals. The guidelines for the individuals and the sections for the individuals are still to be notified. And before the coronavirus, the government was thinking to implement it from June 2020. Okay, but now since the coronavirus is there and it's been everything has been deferred, and practically even the IBC proceeding has been totally, which is going for the corporate, has been deferred as of now. Okay, let's concentrate on the first consider on the corporates. For the corporate, it is provided that 14 days limit for the admission of any application which has been filed by a operational creditor, financial creditor, or a corporate debtor. And if there's any defect, then there is a 7 days time period is being given to the creditor to rectify those things. And under the CIRP, corporate insolvency process, the time time limit is 180 days from the date of commencement of the CIRP proceeding. Okay, which can be extended one time for another 90 days. And IRP, interim resolution professional, will be appointed to be act as a professional or to manage the whole the process on behalf of the I think under the IPC, or maybe they are practically will go with the past official liquidator system and the mechanism as a present mechanism. They are basically now the resolution professions are being substituted with the roles of the official liquidators. So they will be taking up the CIRP proceedings with a time bound limit of 180 days plus 90. Under certain circumstances, the government or certain exceptional circumstances, this 180 days can be extended. There are various judgments of NCLT or NCLAT where they have confirmed that in few cases that in certain avoidable situations it can be extended for further. In one case, it has been extended even by the 180 days. Okay, it is in Gill Metal, Jayaprakash Industries, JP, where they have extended the whole proceedings, CRP proceedings once again, and they started the afresh and given a 180 days afresh to the full proceeding after the admission. Okay, so this is what is available to the NCLT and the adjudication authority. But in IPC, we call the NCLT or these authorities are the adjudicating authority. So when this individual insolvency needs to be notified, so there is nothing is going on in that area. It has been still in the box and is still to be unveiled. When it will come, then the things will be taken up. But since the corporate proceedings are already been notified and the action has been started, so gradually, when there's been a time bound process been provided for the CIRP, and when the matters came before the NCLT and CLAD, and even before the Supreme Court, because in the adjudicating authority for the corporate is NCLT, then appellate authority is NCLAD, and from the question of law, we can go to Supreme Court. NCLT, after going through various problems, I already spoken about the 180 days. In certain exceptional circumstances, they have given the extension for 180 days in certain cases, and even they exclude certain cases. Now, the other criteria which will left is the initial period of admission of the petition or the claim filed by the creditor. So this there is a time given by the to the NCLT 14 days after the filing of after the initiation of the insolvency proceedings before the adjudicating authority, and 7 days are given to the creditor to amend any problem or any shortcoming in the application filed by the creditors. So this when this matters came NCLT and NCLAT was facing various issues, and in one of the judgments, there was question comes and 14 as well as this 180 days is mandatory on a directory. And class after going to I will quote the judgment also, it is Surendra Jain versus Jubilal JK Jute Mills matter. Jubilal Kamalabat Jute Mills Company and Surendra Trading Company. In this NCLAT said this 14 days, 7 days as well as this 180 days. Okay, I'll take the questions, Arvind, Mr. Upadhyay, later on. We have the questions. Just note down the question. We'll take it up later. Let me cover up the topic first, and I will definitely keep some other questions also. Okay. So they give up. They come that these time limits are directly, not mandatory. Okay, but 180 days, they said is a mandatory. 7 and 14 days are directly and clear. And the matter came before again being appealed before the Supreme Court. And Justice Nariman said, I think this is before Mr. Sikri, Justice A. Sikri and Justice Ashok Bhushan. The case came before them, and the question was which they have to examine whether the time limit of 7 days There are other matters also which the NCLAT has held in a different manner, but they said we are just concentrating on Section 7. As of now, Section 7 subsection 4 about the 7 days rectification of the documents in 7 days, taking care of the problems which has been put in the which has been objected by the NCLT. To rectify those in 7 days. That's what the agenda. So we'll be taking up only that matter. And they held up in their presentation in the trading company, saying the is in section the section 7594 as well as 7595 and 104. Here is a talk. There is talk about 7 days period for the rectification of the errors in the pleadings. That is the mandatory one and directory one. And later on, the interpretation which is comes out with all the judgments and other further cases has been brought up before Supreme Court by the NCLAT. And the basic principle which has been defined and which has been agreed with the judiciary and with everybody. That wherever the time limit is prescribed to be taken care by the adjudicating authority, in those cases there is a directory provision. Those provisions are directory. They can decide when and how the time limit is to be implemented. And 180 days is been totally in the hands of the third party, not in the before the court. So that 180 days plus 90 days is the mandatory one. Only in certain cases, it can be, in certain difficulties can be extended or can be certain time can be put it out of. That's when a conclusion will arise between the NCLAT and between the adjudicating authority and the other stakeholders. So this was a situation which was being developed amongst everybody. And if I'll say practically the objective for which the IBC was formed now, which is the time bound manner. If anybody is appearing over the adjudicating authority, before the NCLT or the NCLAT, they all are aware about it. As of now, the addition takes sometimes 6 months, a year, or there are pending for the NCLT, which has been more than 365 days as of now. Okay, to talk about the start of the CRP process. So the whole process, the whole timeline which is being thought of by the Banking Law Reform Committee has been zeroed down or nothing has been going on that. But still, if we talk about the other measure which was prevailing before the coming of the IBC, and if we talk about the negotiable instrument that civil proceedings for the recovery if it's all if it's required, or PRT, SAC, they all are basically even not providing the solution which is been provided by the IBC. Okay. Because if we talk about who are the major sufferers, this time limit is basically majorly been extended for the operational side. Because in the operational creditors cases, there are certain disputes, certain lacking of documentary evidences, which is probably not in the case of the financial creditor. So therefore, in case of operational creditors, the admission taking as of now longer time, and obviously in the financial creditor too, which has been taking a time, which has been not been conceived at the time of formation of the IBC Act. Okay. So, what is the point? Again, because of the compulsions before the judiciary, before the you say about the various constitutional provisions and the fundamental rights are there, which has been challenged by the corporate debtors before the various before the various forums, time has been extended. Even the original concept, the enactment by the parliament has allowed very strict time limits for the various provisions size. Okay. Now, we will talk about now the situation, how the thing is been, because I've just mentioned with the coronavirus, the government has prescribed or been thinking to implement the IC for the install from the also from the June 2020. And now, keeping in mind the economic situation and the ongoing litigations, which could probably be accredited to drag to all the companies or all the industry to this before this NCL, before the authority, and taking action against that, that let us increase the limit which they have announced from 1 to 1. We'll talk about originally in the IBC agreement under section, I think section 4. The original limit is that 1 lakh rupees, the minimum threshold limit, and which can be extended by the central government to the up to maximum 1 crore. And central government, once this situation of COVID has arrived in 23rd March, probably 24th March, they have come up with the announcement the limit, and they have enhanced the limit of threshold limit from 1 lakh to 1 crore. So with that, practically they have some way of given a relief to the MSME sector or the corporates that somebody is a corporate or some creditor should not use this forum as an arm twisting measure against the corporate debtors. Okay, agreed. Fine. This is the demand of the time. They have done it. It is fairly enough and fairly good. Should be done. And the problem lies how the creditors will meet the situation. If how the bankers will take care of it. So I will just told you that for the bankers and the financial institutions, for the financial creditors, the limit of 1 lakh is practically is of no use as because if some banker is given a loan to operate runs the recovery forum, they've been kept out by this amendment. This, I think, as a professionals or as an advocate, all are thinking that will impacting the recovery of money for various MSMEs or various small creditors or operational creditors, we'll talk about specifically. But practically, it will say in the whole reason or whole activity and IBC, you can understood there's only very small percentage of operational creditors who falls into this category. If we talk about the numbers, the amount of coverage or amount of claims which is the NCL. Okay, so so there is more, but other rounds we'll talk about what the government had done. They have enhanced the limit for the MSME sector. Okay, the amendments which have been made for the MSME limits will reduce and wider scope of the MSME sector. Under the report which I've been just reading it out, it says now almost 90% industries fall into the category of MSME. So, major losses from the MSME sector. They've been feeding to the big pockets by supplying various uh, spare parts, various small equipment, small machineries to them, which has been utilized by the big corporate for their businesses. Okay. So, and the government has revised the limit of MSME sector, and a major chunk of 90% industry falls into that. And they have strengthened the MSME machinery simultaneously. It is already there. If somebody has gone to the MSME Act, it says specifically provides if there are outstanding more than 45 days or maybe 60 days, you can check it out in the MSME Act. And a unit has to get registered with some Udyan portal is there, which is the MSME sector. You can get registered. Once they have that certificate, they will be given preference in the payment or the auditors of the company. They are being put under duty to provide compulsory interest on those payments which are pertaining to the MSME. There is no such provision under the Companies Act, under any law, under the Income Tax Act, where the statutory body, the government has prescribed or impose a duty on the auditors, the chartered accountants basically, to provide for interest on the outstanding liability, which is being for the MSME is being there for the MSME. So, if we talk about the whole government, whole story, MSME, I told you the financial creditors is not been impacted with the thing in the late IEC. Only the creditors got impacted with the change in the limit on 1 crore. Okay, and corporate creditors are nothing but okay. And for MSME itself, they have opened up another window, which is the common machinery, a bureaucratic machinery is there, which is there under MSME Act. Duties cost on auditors on the company. And if they don't within a specified time limit, they have to compulsorily pay the interest. And auditors are being put under the duty that to make sure the account confirmation of MSME Act as well as the provisioning of interest on the balance outstanding amount of the MSME. This is what is provided. Now, if any MSME which we are making in a view operation, okay, use recovery proceed on their action under the state where the property line under the Department of Industries, they have formed MSME facilitations centers. Okay, you can file a complaint before the MSME facilitation center, and after that, probably IAS will be there, or maybe next person, next period of that under the IAS, the commission designated person, where you get officer, who will be hearing you, and they will give direction to you to how to proceed for the use within the particular MSME. And they will appoint either they will get the money and the is there a contra ultimates within the party. And arbitrator will be getting an award that will be again enforceable, and that award can be challenged before deposit without depositing the money into the which is that somebody has to get an award. They have to deposit a pre-deposit of 50 to 40% of the money before challenging that amount. So they have given a proper mechanism for the MSME sector also. Yeah, you mechanism for taking care of their debtors. And hasn't been completely of the other big financial leaders because draconian and the whole bigger amount is being stuck in corporates where the process is really useful. I'm twisting by the small operational details by using the identity forum. It will be some time in taken as a good place because small amounts can be or maybe can't be by the companies as far as reasons. And because of that, the small amount of 1 lakh or 5 lakh or 10 lakh, the big corporates or the big companies should not be put into a troublesome situation. That's why this amendment also I feel is the interest of the industry or industry. Another aspect is, I mean, with this amendment that if we talk about the corporates, how from which state is implementing it, or on which kind of cases we having it. So I think Samir or the people they are requesting again and again for the feedback link. It's better to share the feedback link with them so that they can quit and they can join the other session wherever they have to join. Please do that. I think we should not hold any rules. If there are certain other agencies, we should allow them to be. Okay. Okay, fine. So now, thank you, Arvind. Okay. Uh, thank you. Thank you, please. Complete. Now, I've been talking that how this amendment is impacting the competitors or the present cases which is going before the NCLT and why you will actually get taken. So for those things, it is understood that this lost my brother. So various messages are becoming on saying here in the chat box. It will distract me. Okay, I was talking about for the cases already admitted, but admitted before that. After the date of this announcement will be considered as 1 crore. Fresh cases can't be filed. Whatever is filed but not admitted or under objection, that all can be treated under the old limit of 1 lakh. In all new cases, if it is filed, if you issue a demand notice, that won't consider. As of now, this judgment will be given by the state to Chennai, on which they have basically filed and pending the adjudicating authority will be considered under the old limit and any fresh filing after the 24th March 2020 date that will be considered under the new limit. If the matter you have issued the demand notice, that won't be considered in case of operational charges. Okay. On financial credit, just mentioned to you that for the lakh rupees respective, it is for the commercial and that we now it is there on the MSN. Okay, because the roads are shut down as of now, they are not taking the metros today. Or this kind of disputes of recovery money, they can go for the MSME facilitation centers and they can go for the recovery of them. They are actively working and you can recover their money from them. To that mode, you can recover money from the MSME facilitation center, but they can help you to see the recovery of the money. Or almost one more and trust is already already okay. The moment we have from that date onward, I just is already been unless and until there's a provision by understanding, unless there is something separately is being agreed between the parties. And even if that comes on the more mechanism whereby they have said the RBI is providing a mechanism where there is a sort of a registration for this SME setup if the supplier as well as the buyer and seller both are listed under that mechanism and the MSME, the MSME, then automatically the bank will in the restoration into the account of the MSME. So this is what is also there. So if somebody is being cautious that whether he'll be getting MSME capital, you can advise the client to MSME business owners that look for the companies or the buyers who are having a registration under MSME. No, specifically they have obviously if they have the MSME, then how can we that? How can we select? It is for the buyer that the buyer that are registered under MSME. It is almost like same. But when an MME makes a supply to that industry, that company, they will automatically, when the balance is there, they will transfer the fund to the MSME account after completion of the specified time limit as provided under the MSME Act. So this is the mechanism for future acts. And if there are outstanding cash, then you can go to the relationship counter and pay matter. And after final credit is been taken care by the so that I don't go the COVID-19 there was some lots of people are saying that IBC is practically spending into plenty. So that is not my opinion. I'm a little bit different from the opinion of the offices. It is very the keeping in mind of this pandemic situation. We are not able to see of so many situations, so many things, which is in the normal circumstances not possible. So this structure is practically and suitable here. So, yeah, should we take the questions first, or should we continue with the deliberation on the
Please complete that.
So we can
very important and impacted the whole structure of the IPC, which was not there. And 29. I will introduce you what is the section 29A. Initially, when IPC was notified, there was no provisions there that how and the existing promoters will participate in resolution process of the companies to which they were the promoted. are steel metals, when these metals came up for the first time, but the years were trying to take a back the entry and do again at the company. When the metal was came before various courts and this was being raised up, and the government decided and amended the IPC Act and instead a new provision under Section 29. Under Section 29A, what they are provided at if a promoter there are certain avoidance which is provided. If there is preferential transactions for the creditors, there are fraudulent activities by the corporate against the creditors. In those cases, they said if promoter is involved, the corporate debtor he was the basically or he was a director okay, or promoter. Now it means the CIP starting it's a suspended board. Applicant can be there and then can give a process for the liability of the company. Once CRP was 180 days to 90 days finished, the liquidation proceeding also the liquidator have, but there won't be any right to give a resolution plan. The resolution plan is then things are going on. Okay. So at that juncture, the promoters and the or the rest factors are the powers have been suspended, but they still remain as a directors or promoter. And when the liquidation proceeding starts, the stakeholders and their reporting right away they can be they removed from the position which they will be in the liquidation. The operator has incurred in the past. So those people, those promoters are not eligible to consider the resolution plan. They can't be a resolution applicant. A person, resolution applicant means a person who will submit a plan for the company. So those promoters, if they follow this kind of an activity, they are being into some kind of activity which is not come as a good one according to the criteria. Those promoters can't be participated in the bigger amendment which is amendment made after that inspection of the eligibility and uh, the solvency we would have to basically make area on which we have to control that. Okay. So one more thing I would like to discuss is if you people been they have prescribed various they have found the Insolvency and Bankruptcy Board of India. And when the IBC was notified, they have provided four rules. The central government has provided four or six rules. Six rules, sir? Can you check it out? Anybody? Okay, there are they provided four, five rules. Which have been formed by the central government. Even the rest of the things, and they are notified by major, the main act. And for the rest of the things, they are given the power to IBBI to form various regulations on the various.